Alrighty, folks. Thank you for joining us and watching this recording. I'm really pleased to welcome Kevin Souls, who is a patent attorney in Albuquerque. And we're going to talk to Kevin about kind of why does it make sense to use attorney services? What are some of the things that people often overlook? And just what are some critical aspects of the patent application that you really need to be aware of? Kevin, thank you so much for being able to join us here today. I really appreciate it. Can you go ahead and introduce yourself to the audience?
Sure. Yeah. So I'm an intellectual property attorney with Loza and Loza. We have offices all over the country, but I'm located in Albuquerque. My principal practice focuses on trademarks, patents, copyrights, trade secrets. So, we do a lot of patent applications for big clients, startups, all different types of people that need protection for the intellectual property that they're developing.
Great. Thanks, Kevin. And so for anyone listening, obviously, Kevin has worked on quite a few different types of intellectual property protections, kind of a wide band. So given that, Kevin, what do you think, just in your opinion, is the most critical aspect of intellectual property protections?
It's a good question, a hard question to answer because there's a huge amount that goes into intellectual property protection. But if you're talking about somebody that's at the beginning stages, I think the most important thing you can do is educate yourself as to the type of protection that the various forms of filings can offer. Copyrights protect one thing, trademarks protect branding or source identification. Patents are protection for ideas, functionality, things like that. So I think it's definitely worth, before diving in headfirst, to get a picture of what your technology is, what your intellectual property is, and what the best vehicle is for protecting that type of intellectual property.
Yeah, I'm really glad you kind of gave that answer, Kevin, because that's the entire purpose for why we're doing this, self-guided course, is to give people that introduction into intellectual property and kind of their patent. And since we have throughout our, different modules, our different trainings, the interviews here, we have a very large focus on patents because that's where we see the most critical gap. In your eyes, what do you think is something that most of your clients overlook when they're trying to patent their technology?
I'm going to give you two answers to this question because I think they're actually two critically important things here. The first is claim scope. So when you file a patent application, it goes through a process, ultimately ends up with a right. And the right that you have, that exclusionary patent right, is defined by the claims. So I think a lot of people misunderstand the scope of their patent right, which is defined by those claims. I think that it's really important to understand what your patent gives you and how that's defined in the claim. So I think probably a misconception I see from people a lot, or something they overlook, is they just want a patent, right? And I like to use real property analogies. So for example, if you have half an acre in Doña Ana County of real property and half an acre of property on Manhattan, those two things are worth a really different amount, right? Claim scope is the same way. A very narrow patent claim is not worth nearly as much as a big, broad claim. So it's worth understanding what that right is when you get it.
That's an excellent point there. And that's something that, we, even in the kind of training and just knowledge that we're trying to provide, claims seem like they're so important and such a huge thing when someone's trying to protect their invention, protect their technology. And it seems like starting out wrong on that pathway is a really great way to just stumble your way through the entire process. I've seen just a lot of literature out there that, since claims are so integral, that's something that you might want to get outside assistance for. So kind of given that, Why, in your eyes, and feel free to dive further into that point or have a different point, why should someone consider using a professional patent lawyer such as yourself instead of trying to do this themselves?
So I think we should stick to the idea of claims here. Claims are deceptive. If you read a patent application or a registered patent, there's maybe 20 pages of description, specification, and then a tiny little section at the end that defines what the rights are, the claims. Okay. And writing claims is incredibly technical. There are aspects of claims that I think even an attorney that's practiced for a few years may not fully understand. It takes a long time to understand the nature of a claim. And if you're trying to write claims yourself, there are a ton of little pitfalls that you can fall into that will tank the value of your application. So, as an example, it's sort of counterintuitive, but the more that you have in a claim, the more features you have in a claim, the narrower and less enforceable it is. So I think people that are trying to self-file oftentimes want to write claims that include everything that they've come up with. But what they don't realize is that that makes their claim very narrow and very unenforceable, which I don't think is sort of the picture you would have as you're writing a claim without having gone through the process many times, litigating patent scope in court. So I think maybe getting a patent attorney to work on your claims for you is just a critically important aspect. They will increase the value of the ultimately registered patent a huge amount.
I'm glad you bring that up because it's something that we've seen even when I worked for the intellectual property office here at New Mexico State University. Is getting claims right can be a huge struggle. As you said, they have to be very technical, but I also like to tell people it's almost like a creative writing process, but being technical, because you kind of have to figure that out. You have to figure out, what do I need to do here to make sure I have the easiest path, if nothing else, to actually getting a patent awarded. So we covered a lot of information here. If there was one critical piece of advice, critical last thought you could leave the audience with, what would that be and why?
Yeah, I think maybe a piece of advice that I would leave your audience with is that the patent system is a process. I think that a lot of people have in their mind that you kind of file a patent application, wait a little while, and then you get a patent and it's yours, and that's the end of it. And there really is a lot more that goes into the registration of a patent and then the enforcement of your patent rights, if necessary, down the road. So just as you pointed out, Del, as you move through that process, you need to get claims that are enforceable in view of the prior art references that the examiner finds. And that's a process. So you could get narrower claims that are maybe easier to get an allowance for, or broader claims and it's more difficult. There's a whole array of other things that you might need to do after your patent has been allowed. So I would suggest that people speak with their patent attorney or intellectual property advisor and get a picture of what the patent process looks like, because it's complicated and certainly more complicated than just file an application, get a patent. There's a lot that goes into it.
Yeah, I think that really does underscore your point about, if nothing else, at least have a conversation with an IP attorney, talk to them about what you're doing, see if you can get that help, because there are so many kind of almost stage gates along this process that it's like, okay, I could really use some outsider assistance here. I could use some knowledge, some expertise from someone that's been through this process and been through this process a lot. Well, I think that, covers a lot of really, really strong and great information for our audience. I want to thank you so much, Kevin, for taking time out to kind of talk about what does this look like, what people should be aware of, and almost the hidden gotchas that people just really don't think about when they're going, I need to get my patent, I need to set this up. And Along those same lines, kind of going back to your last point, I like how you talked about the patent process and it's being this process, because that's one thing that we've tried to reinforce with people is patenting goes with your business process. It's not your business itself. It is an aspect of your business. So along those lines, is there anything else you'd like to leave the audience with today?
I think that just as you've said, it's important to speak to a patent professional if you're considering getting a patent. A lot of patent attorneys will do consultations for free. Our firm does consultations for free. And I think that those are really enlightening for people a lot of times. So definitely worth reaching out and speaking to an attorney. And Del, I love what you guys are doing. I think this is such a fantastic way to educate people that are kind of starting up or getting involved in the intellectual property aspects of their business. So I thank you for having me on and letting me share a little bit of this information.
Oh, well, no problem at all. Thank you, Kevin. And I think your last point is a really great one to end the interview with, because we always like to end on a high note, and a high note, thinking that we're doing a great job, is always a good way to close out. So thank you, audience, and look forward to more information from us. And as you move through these modules, just let us know if anything is confusing, anything needs some further explanation, or if you want to contact one of our interviewees like Kevin and make use of that free consultation for what do I have? Is this worth it? Is this something I should do? So thank you again, Kevin. Thank you, audience, and we will see y'all next time.